Felix Reda is a former member of the EU Parliament. He was a member of Parliament while the copyright reform that produced the directive I just mentioned was being considered by the European Parliament between 2014 and 2019. And that law, I believe, is the first regional law or agreement requiring its members to protect certain TDM uses for copyright control. Felix now leads a strategic litigation project called Control Copyright, which is designed to strengthen communication freedoms. Felix, take it away.
Yeah, thanks a lot, Sean. It's been really interesting to see all the similarities actually between the US and the EU legal situation on text and data mining, even though in the EU, as you well know, we do not have an open norm such as fair use, but rather we have a list of specific exceptions and limitations, which at least, however, have been elevated to the status of users' rights by the European Court of Justice recently. So in that respect, at least we have a similar approach now that text and data mining is conceptualized as a user's right under copyright law. But being a political scientist and a politician rather than a lawyer, I do want to approach the EU situation less from a kind of legal analysis point of view, but rather tell you how we ended up with these two copyright exceptions for text and data mining in EU law. And we actually have two of them, one covering text and data mining for research purposes, which is pretty similar to what Michael has been talking about. And then we have a second text and data mining reception for all other purposes, which might be closer to the copyright aspects, at least, of the Clearview AI example that Michael has given, of course, with the caveat that we do have EU-wide data protection laws that very much limit the ability to use facial data for facial recognition purposes. But at least from a copyright perspective, the second copyright exception that we have for commercial text and data mining outside of the research field might also apply to things like Clearview AI. So basically, when the copyright directive was proposed by the European Commission in 2016, it was intending to solve a very specific problem, which I think best compares to the Elsevier license that Michael has just shown. So even though in Europe we do have, or we already did have, an exception to copyright for research purpose, at least non-commercial research, and we do also have an exception for transitory copies. So simply basically transmitting a copyright protected work through a network or storing it in your computer's memory or your cache for a limited period of time wouldn't be a copyright infringement under EU law either. Nevertheless, researchers were actively being prevented from exercising their right to research for TDM purposes before the copyright directive was proposed. And it was actually researchers from the UK that originally were raising this problem. And at the time, of course, the UK was still part of the European Union and had quite a lot of influence on EU politics. So they very much spoke up on behalf of their researchers and were saying that European researchers were falling behind because academic publishers would simply not put them in a position to be able to exercise their right to research when it comes to text and data mining. So most of those researchers would be employed at a public university. That university would have subscriptions to some academic journals from commercial publishers such as Elsevier. But what would happen if a researcher actually tried to use that access to perform text and data mining? So either they would have to go through a commercial licensing-based TDM offer, such as the one that Michael presented by Elsevier, which did not meet the actual needs of researchers in many ways. So for example, by preventing them from being able to share the data set, which would make the research results not reproducible, or simply not offering the technical tools that they would need to perform their analysis. So if a researcher tries to bulk download a huge number of research articles to perform the text and data mining on their own machine, they wouldn't be breaking any copyright laws. I mean, provided that they have access to the academic journal, they are perfectly within their right to download those research articles and then perform an analysis. I mean, the technical temporary copying exception under EU law would also allow for such an analysis to happen. However, contractually and also technologically, the academic publishers would prevent researchers from doing so in different ways. So for example, they might monitor how many articles are being downloaded from the same IP address and block that IP address if it would look like they are trying to bulk download articles. Or they would get in touch with the research institution like the academic library or the university and say, we have detected suspicious activities from an IP address in your network or something like that. So essentially, they would either contractually or technologically prevent the researchers from being able to bulk download the articles, or the articles would only be available in a format such as PDF format that would make it extremely difficult to perform text and data mining research. So essentially, the researchers were saying, look, our universities are paying a lot of money for access to these academic journals. The least that the legislator should do would be to make sure that once we have paid for this access, we're actually able to use these articles in our research. And of course, nowadays, it doesn't mean that you download a single article and read it, but that you're actually able to use technological tools such as text and data mining to analyze large data sets. And so the European Commission reacted to this demand by introducing a proposal for one text and data mining exception, which would be limited to research purposes, which is Article 3 of the Copyright Directive as it was adopted. So this is text and data mining for the purposes of scientific research. And I would argue that to a large extent, it doesn't really address the problem because it only says that users have the right under copyright law to make reproductions of articles or any other copyright protected works for TDM purposes, but it doesn't necessarily put them in a position to do so in practice. However, there is one really important change that came along with that, which is, I think, different from the legal situation in the US, and perhaps the one point where it is superior, which is that the European Union also made sure that this copyright exception for research purposes, research-based TDM, would be protected from contractual overrides. So this means if Elsevier basically said, we are only going to give you access to the research articles if you agree to our vision of text and data mining as part of the terms and conditions, then those contractual provisions that limit the exercise of text and data mining are actually unenforceable in the European Union. So you cannot contract away your right to perform text and data mining under European law. However, there are some shortcomings compared to what Michael has explained about the fair use doctrine, most notably that this text and data mining exception is limited to content to which the users have lawful access, which raises some questions because, of course, accessing content that may have been uploaded without permission as such is not a copyright infringement, but there is some legal uncertainty over what it actually means to have lawful access. So does lawful access mean that the source from which you are obtaining the data for text and data mining has been made available legally? This would put researchers in quite a difficult situation if they're scraping content from the internet for research, for example, because it's not always the case that the data that is being used for text and data mining are academic research articles downloaded from a publisher's website. There is a lot of text and data mining, especially, for example, in the humanities, that looks at communication or any other text or content that is being shared on the internet as the basis for the research. And there is simply no way for a researcher to be able to ascertain whether every piece of information that they find, for example, on a social media page, has been made available lawfully. So I would say the only reasonable and operationalizable interpretation of this provision, that the user must have lawful access, is that the user has not broken any laws in accessing the content. Because otherwise it would be impossible for somebody to actually use the text and data mining exception in an internet environment while being absolutely sure that all the content that they are incorporating in their text and data mining research has been made available lawfully. However, we also have the problem that this text and data mining exception is limited to purposes of scientific research. And as has been mentioned earlier by Michael, when looking at the case law in the United States, a lot of things that are simply core functions of digital technology and the internet can be conceptualized as text and data mining. For example, having a search engine of websites that are freely available on the internet. And obviously, if we said that having a search engine constitutes copyright infringement or requires the express permission of every website holder, that would cause a lot of problems. Like, you might even say, if copyright law was strictly interpreted as basically prohibiting any kind of copy, including temporary copies and indexing, that would just fly in the face of the way that our society works in a digital age. Obviously, having a search engine index websites is not a copyright infringement, and this has also been confirmed by a court ruling in Germany, for example. But the introduction of a specific text and data mining exception, which is limited to research purposes and research purposes only, raised the question, well, does this mean that by analogy, all other uses of text and data mining outside of the purpose of scientific research are considered illegal under EU copyright law? This is a question that was raised after the European Commission had made this proposal for text and data mining for purposes of scientific research, which is why today we have two exceptions for text and data mining. And those are Article 3 and Article 4 of the directive. Article 3 is basically the amended version of the original text and data mining exception as it was adopted by the legislator. And this is basically permitting reproductions, including long-term reproductions of copies for text and data mining purposes. So here you can see research organizations and also libraries, archives, and so on, including their members, are able to make copies of any kind of work for text and data mining purposes, and they're allowed to store those copies long-term to basically ensure the reproducibility of results. Problem there is that it only covers the making of reproductions. It doesn't cover actually making available those reproductions to third parties, which of course means that if you actually want to reproduce the research, you need to have another legal basis to actually send the stored copies to a third party. But Article 4 is the general exception for text and data mining, and this is the exception that covers all uses that are not for the purposes of scientific research. By the way, neither of those exceptions is limited to non-commercial purposes. So what matters is whether the text and data mining is performed by a research organization for research purposes. In that case, this exception cannot be overwritten by contract. And so the kinds of Elsevier provisions would be unenforceable against researchers. And Article 4 is the general text and data mining exception, which can be overwritten by contract. And this is the thing that you see in paragraph 3 here, which was criticized at the time as being sort of a weird approach, that you have an exception to copyright and then you have an exception to the exception in a way, which says that this exception to copyright or this user's right does not apply if the right holder has reserved their use in an appropriate manner. And then it clarifies that in the context of online uses, an appropriate manner means machine readable. So basically what this provision is doing is basically just clarifying that what everybody has been doing all along, indexing websites and then providing services on the basis of that, such as a search engine, is not a copyright infringement. However, users or website operators are able to opt out of that, which is also something that they have been doing all along. So in the context of search engines, if you run a website, you have a file called robot.txt, robot text, where you can basically tell the robots that are scraping websites on the internet that you don't want your website to be scraped. And this is what this opt-out essentially is. It's a machine readable way of telling the text and data mining scraper that you do not want particular content to be included in the text and data mining. And this provision sort of elevates this technical convention that everybody has been following to a copyright provision, which basically says if you're not respecting the robot's text, you are infringing copyright because you don't have the permission of the right holder to perform this text and data mining. I would say that this is not such a big problem, because if you conceive of copyright exceptions to users' right as users' rights, which increasingly under EU copyright law are protected from contractual overrides. So this means that your users' rights cannot be contracted away. All that this provision is saying that, well, in the case of this commercial text and data mining, your user's right can be contracted away, because the right holder does have the possibility to contractually require you not to include it, or even make access to the content conditional on you not using it for text and data mining purposes. But even so, I would say the provision under EU law is a little bit better than simply being silent on contractual questions, because at least it says that this opt-out by the right holder has to be machine readable. So in a way, this is making it easier for those who perform text and data mining in an internet context, because they do not have to ask individual permission.
Thanks, Felix. There's a lot of really interesting intersections, and I'm hearing a lot that intersects with some of the themes that we've been spelling out in the course, especially really useful information about defining in both places some of these exceptions as being within a rights construct. That's going to be really fun to talk more about. So, but before I jump in, normally what we do at this point in the lecture is turn it over to some members of our teams who have agreed to read a little bit more deeply and pose questions to the audience.